Hello, I'm Sean Rehag. I'm the director of York University Center for Refugee Studies. I'm also the director of the Refugee Law Lab, and I'm an associate professor at Osgoode Hall Law School. This video has been prepared for a workshop on fact-finding in immigration detention reviews, which is a workshop that aims to bring together people working on evidence law and people working on administrative law. Now, often when people think about evidence law, they think about rules on admissibility. Can a particular piece of evidence be admitted or be considered in a particular legal proceeding? And so it may seem a little bit surprising that the workshop organizers have chosen immigration detention as a case study for thinking about the interplay between evidence law and administrative law, because the authorizing statute for immigration detention reviews explicitly says that the typical rules of evidence, and specifically the legal and technical rules of evidence, do not apply in this context, and that instead the tribunal that decides immigration detention reviews can consider evidence that is credible and trustworthy. Now, if one adopts a broader understanding of evidence law, that is, if one thinks of evidence law not just as being about rules relating to the admissibility of evidence, but rather a whole series of rules that helps decision makers reason with evidence, that is, that it helps decision makers figure out what information the decision maker should consider, how it should consider that information, how it should evaluate that information, how that information should factor into the decision-making process. If we understand evidence law in that broad sense, it's clear that immigration detention reviews will necessarily implicate evidence law. Because even if the technical rules about the admissibility of evidence do not apply, decision makers still need to decide how they're going to handle evidence, how they're going to interpret evidence, what inferences they're going to draw from the information that is before them. And so administrative decision makers in the immigration detention context, but really administrative decision makers in virtually all contexts, need to engage with what we might consider evidence law on this broad understanding. Okay, so one of the questions that the workshop organizers are wanting to get us to think about in this workshop is what is to be gained if we were to understand evidence in this very broad way, and if we were to spend more time thinking about what evidence law and administrative law have to say to one another. Well, one of the benefits, I think, of bringing together evidence law and administrative law in this way is that it encourages us to engage with interdisciplinary research that's been conducted in the migration law field. So I'm an interdisciplinary, empirically minded researcher. My research is in the migration law setting, but it focuses on the refugee law context. Much of that research has tried to understand outcomes in Canada's refugee determination process. And what I'd like to do in the remainder of this video is explore what I see as some of the implications of that research for those of us interested in the intersection between administrative law and evidence law. And I want to talk about three research projects of mine with a focus on one research experiment. Okay, so let's jump right into the research that I wanted to talk about. The first research project that I wanted to share with you involves quantitative work on Canada's refugee determination process as a whole. The work is inspired by research in the United States, a famous study called Refugee Roulette, that showed that outcomes in U.S. asylum applications hinged, at least in part, on who the decision maker was. And I was interested in seeing whether the same was true in Canada. And so I did an access to information request. I obtained data on all outcomes in Canada's refugee determination process in, I think, 2006. And I did some statistical analysis on that data set. And what it revealed was that some decision makers were much more likely to grant refugee protection than others. There were some adjudicators that had very low grant rates, between 0% and 5%. And there were others that granted refugee protection in every single case that they heard. And what I do in the article that you can find right here is that I look at various factors that might account for those variations. And I do, of course, find that there are a number of reasonable explanations for part of the variability, explanations relating to decision makers, for example, specializing in particular regions of the world. It makes sense that if you're hearing claims mostly from countries with very high success rates, that your grant rates are going to be higher than colleagues who are hearing claims mostly from countries where claims are not often successful. So that was one factor that was influencing variations in grant rates, and there were a series of others. But what I conclude in this article is that even when you try to account for those factors, it does appear that there's a great deal of subjectivity in Canada's refugee determination process, and that outcomes, at least part of the time, hinge on the luck of the draw. So that was the first study that I did. I used that research to try to make a number of policy recommendations about how to improve consistency in outcomes, including, for example, making sure that all unsuccessful claimants have access to an appeal on the merits. Okay. The next bit of research that I want to share with you tries to understand a little bit more why we might be seeing these variations in success rates across decision makers. So in some of the earlier research that I did, I saw that there were a handful of decision makers who had denied every single claim that they heard over several years. And I continued to do research on this, doing yearly requests for information from the Immigration and Refugee Board, and putting up statistics about that online on the Canadian Council for Refugees website. And it turned out that there was one decision maker who, over the course of several years, decided a couple hundred cases. And in each of those cases, the decision maker denied the claim. And so I was interested in trying to understand more about what was going on in these cases. And so I did access to information requests to get anonymized and sanitized versions of all of these decisions. So the full data set of this decision maker who denied all claims over a 3-year period. And I looked at those cases to try to understand what was going on in the decisions. And so one of the things that I did is I looked at the country of origin in all of the cases to try to see if that was an explanation. And that did, in fact, partly explain the low success rates. This decision maker mostly heard claims where claimants were from countries with low overall success rates. But when I did some statistical analysis on that, it suggested that even when you take into account that the decision maker was mostly hearing cases from low success rate countries, this decision maker was still much less likely to grant refugee protection than his colleagues in cases from the same countries. And you can see on the screen here some of those statistics. I also took a look at the reasons that the decision maker offered to justify the negative refugee determinations. And it was interesting to see that the decision maker seldom believed the claimant. So, out of 174 cases, the decision maker explicitly found the claimant not to be credible in about two-thirds of those cases. And when the decision maker found the claimant not to be credible, it wasn't just, I don't believe, kind of one part of the narrative. Rather, the decision maker asserted that he didn't believe any of the narrative. And there was this kind of stock paragraph that was included in many of those decisions saying, I simply don't believe that the events recounted by the claimant actually occurred. And so that's why I titled the article that sets out the findings of this study, I simply don't believe. So that was two-thirds of the decision. In another 20% of the decision maker said that he didn't necessarily disbelieve the claimant, but that should not be taken to mean that he believed the claimant. And again, he used kind of language that was cut and pasted from other decisions where he takes care to say, I'm not finding that the claimant wasn't credible, but I'm also not finding that the claimant was credible. In about 10% of the cases, there was just no discussion of credibility at all. And in less than 1% of the cases, and in fact only one decision, the decision maker explicitly said that he believed the claimant, but then denied the claim on other grounds, that the claimant did not meet the kind of legal definition of a refugee. Interestingly, in that one case, the decision maker was not deciding the case alone. He was deciding the case on a panel of three decision makers, which is a process that can be used at the Immigration and Refugee Board. So what this research showed was not only that this decision maker was deciding cases differently than his colleagues, but that the specific site for the kind of reasons that were offered for denying claims at a higher rate than colleagues deciding cases from similar countries related to fact-finding, and specifically to whether the claimant was credible. All right, so this brings us to the third project that I wanted to discuss. This project is a research experiment that I conducted with a colleague, Hilary Evans Cameron, who's one of the co-organizers of this workshop. The project seeks to understand a little bit more what might be causing the sorts of subjectivity in refugee adjudication that were observed in the prior two projects. And so we used a research experiment to do that. The experiment involved around 300 students at a law school. The participants in the experiment served as simulated refugee adjudicators. They reviewed a sexual orientation-based refugee claim, and the only issue in that claim was a factual issue. The factual issue was whether or not the claimant was telling the truth about their sexual orientation. So if they were able to establish that this was a claim involving a person who said that he was a gay man, if he was able to establish that he was gay, he would obtain refugee protection in Canada. So the students took a look at a case file. The file was identical for all of the students who saw who served as simulated adjudicators, except that the students were divided up into three groups. One group saw the case file, and in addition, they saw a photo of someone who presented in a way that research that we had done suggested would be perceived as stereotypically quote-unquote gay. The second group, so this was a second third of the students, saw a photo, saw the same case file, but it included a photo of a claimant whose physical presentation tracked on to stereotypes that the research that we did suggested led people to infer that a person was straight. And then another group of students served as the control, and that group did not see any image. The participants, after they reviewed the case file, had to make a credibility assessment. Did they believe the claimant with respect to his assertions about his sexual orientation? And the participants were asked to write a brief decision explaining their credibility assessment. The participants were also incentivized. They were provided with the possibility of obtaining a gift certificate that could be used at a local coffee shop. And they would receive that gift certificate if the decisions that they wrote complied with basic principles of administrative law. And we provided the students with some guidelines on what those principles were. Well, here are the results of the research experiment. And perhaps not surprisingly, students who saw the file with the quote-unquote gay presentation photo were more likely to believe the claimant than students who saw the file with a quote-unquote straight presentation photo. And the difference was 88% of students who saw the first photo believed the claimant, and 75% believed the claimant if they saw the second photo. So we know that the photo had an impact on whether the simulated adjudicators believed the claimant. But what was interesting was that phenomenon was not transparent in the reasons that the students had offered to justify their credibility determinations. That is, students did not mention the physical appearance of the claimant. In fact, there was only one out of 284 students referred to the physical appearance of the claimant. And you can see the full quote about that from their decision on the screen. And so what we conclude from that is that there appears to be a distinction in fact-finding between factors that influence fact-finding and credibility assessment on the one hand, and the rationales that are offered for decisions on the other hand. In other words, there's a difference between decision-making and decision-writing. We also found that looking through the decisions, although the decision makers, the simulated adjudicators, didn't typically refer to the physical appearance of the claimant, they did draw on other stereotypes about sexual minorities in their decisions. And so in the case file, there was some evidence that the claimant had engaged in sexual activity with a member of the opposite sex. And you can see some quotes here on the screen where students drew inferences that due to that, the claimant was not, in fact, gay. And we know that human sexuality is complicated, that there's a distinction between sexual behavior and sexual orientation, that people engage in cross-sex sex for any number of reasons, that lots of people who identify as gay may have children, for example, and there's guidance in case law saying that one should not draw on these factors in making decisions. And yet we still see these stereotypes visibly in the decisions. We wondered whether those stereotypes were also affecting decision-making when they were not visible in the decisions. Another thing that we found that was interesting when we reviewed the decisions written by the simulated adjudicators was that many of the simulated adjudicators approached the exact same evidence very differently. And so one of the bits of information in the case file that the students looked at was that there was a contradiction between the date that the claimant said that he had come out and the date that his mother said that he had come out in an affidavit that she had provided to support his application. And so what you see on the screen here is that some students found this to be very persuasive evidence that the claimant was not being truthful, on the theory that surely the mother would remember something as significant as her child coming out to her, particularly in a context where the claimant was from a country where it was very dangerous to be openly gay. Other students, though, encountering the very same information, came to different conclusions. They concluded that, it's not unusual that a parent might mix up the precise timing of when a particular event was recounted. One student noted that that his or her mother forgot when they had come out to her. Another student wrote that their mother often forgets what year they were born, let alone when they found out a personal fact about them. And so it was striking. This is just kind of one example, but on any given piece of information in the case file, what we saw was that some adjudicators thought that that piece of information was very important. Others thought that it wasn't very important at all. And sometimes adjudicators drew diametrically opposed conclusions from the same evidence. So what does all of this suggest? Well, one of the things that we think is implied by this research that we've done is that really there's a need for a lot more research on factors that affect fact-finding and credibility assessments. In particular, there's a need for more empirical research in this area. There's also a need for research that looks more carefully at the connection and possible distinction between decision writing on the one hand and decision making on the other hand. Often people with legal training really focus on decision writing. They try to understand the kind of legal norms that are at play in the decision writing process. But we also need to pay attention to decision making, because as we saw in this study, there are factors that can influence decision making that might not be transparent in decision writing. There's also a need for ongoing efforts to combat problematic reasoning and the use of stereotypes in fact-finding involving sexual minorities, both in terms of both in terms of decision writing and in terms of decision making. Okay, so let's return to the broader themes of the workshop and the question of what is to be gained by bringing evidence law and administrative law together. I think that one of the things that is to be gained is that if we think about evidence law broadly as a body of law that deals with how decision makers should grapple with information, what information they should consider, how they should consider that information, what weight they should give to information, what is good information, what is bad information, how should they integrate information into their decision-making processes, then I think evidence law gains access to the kind of empirical research that I've described in this video, because this research is, in a way, all about different ways of grappling with information, different ways that subjectivity in grappling with information affects outcomes in administrative processes. And so I think evidence law scholars should engage with this kind of research, not just in the migration law context, but in any number of administrative law contexts, and indeed should be doing similar types of research in the criminal law and civil litigation contexts. I also think that there's a lot to be gained for those of us working on the administrative law side by engaging with evidence law in this way, because evidence law can help us think through how to respond to some of the challenges that the research that I've described in this video raises. For example, how might different approaches to the standard of proof or the burden of proof be used to address subjectivity in refugee adjudication? Or how might we use soft law processes, guidelines, training for decision makers to improve decision making? How might people working in the migration law setting, decision makers who are involved in immigration detention, for example, benefit from lessons that have been learned by decision makers who are struggling with how to handle information in the criminal law context or in the civil litigation context? So I think there's much to be learned by encouraging a kind of rapprochement between evidence law and administrative law. And I'm very much looking forward to the workshop so that I can hear more about other ways that bringing these two areas together might enrich both disciplines. So thank you very much, and I'm looking forward to seeing all of you at the upcoming workshop.